I represented a man whose father died and his stepmother refused to give him anything from his father's estate. Her attitude was, where's your birth certificate with your daddy's name on it? Where's your DNA test? Where's the paternity case? Can you believe it? Can you believe that? This is attorney Vernita Williams, your heirs property attorney. I discuss all kinds of things related to estates, heirs property, and all of the dilemmas and sagas that go along with it. This particular case, in which I represented a young man, he's not somebody that didn't have a relationship with his stepmother. Believe it or not, he spent every summer with his stepmother and his dad for about 15 years before he graduated from high school. There was never an issue about a birth certificate. His dad's name was never on his birth certificate. He never pursued that. But after his dad died, his dad's name not being on the birth certificate became one big emotional drama and unpleasantry. Would you believe that his stepmother did probate, did not name the young man, put the husband's property in her name, sold the property, did not give the young man a dime? So, here's something that I want to recommend, because there are many, many, many people without their dad's name on the birth certificate. It's really not an issue until it's an issue. So, I want to tell you 5 things. If you are a person and your father's name is not on your birth certificate, step number 1, get a copy of your birth certificate. Look at it carefully. See what is there. Your dad's name might be on it, or your dad's name may not be on it, or somebody else's name is on it. I've recommended this to people, and it turned out that the dad's name wasn't on the birth certificate, but somebody else was on the birth certificate, because that person agreed to be on there, and the mother of the child in that particular case chose this man because he was more economically stable. Anyway, get a copy of your birth certificate and see who's on there. If your father's name is not on there, step number 2. If your dad's name is not on your birth certificate, gather information in which your father acknowledged you. Something as simple as a birthday card in which your dad said, "Happy birthday to the greatest daughter in the world." Hold on to that. It could have a lot of merit and significance in years to come. A Christmas card from your dad. Anything in which he acknowledged you. If you were a child and your dad put you on his health insurance at his job, or life insurance as a beneficiary, anywhere where your father acknowledged you will turn out to be extremely important in the future. Now, let me caution you. If your father passed away and somebody was kind enough to put your name on a funeral program, that is not what the Florida statute calls an acknowledgement, because somebody other than your dad did that funeral program, so that's not the kind of acknowledgement they're looking for. The Florida statute and the Florida case law is looking for an acknowledgement in which your dad drafted the document or filled out an application and indicated that you are his child. That's step 2. Find anything where your dad acknowledged you. Step 3. If your father is still living, then you can go to your father and say, "Listen, I know that your name is not on my birth certificate." So if your father is alive, there are steps that you can take to put him on your birth certificate. There are steps that your dad can take to acknowledge you, such as doing a last will and testament. There are things that can be done. That could be a very, very sensitive situation, because some dads, even if you have a relationship with them, they might feel some kind of way if you step to them and say, "Hey, I need you to do something a little bit more than what you're doing. I don't want to be left out. I don't want to be denied. I need you to formalize the fact that you're my dad." So if the father is still alive, you can get a last will and testament, or he can just voluntarily go through the statutory process of putting himself on your birth certificate. Step number 4, if your father is alive, you can do a paternity test. Now, I don't know if a paternity test is necessary if your father is willing to place himself on your birth certificate, or if your father is willing to do a last will and testament and acknowledge you. Now, step number 5, and this is extremely important. There are several different laws in the state of Florida that talk about how to establish paternity. Some of them restrict how long you have to establish it. Some of them state what are the methods by which you can establish it. It's very important for you to go and sit with an attorney and explain your fact pattern, and let that attorney tell you how the law applies to your situation. There are some situations, for instance, if you were already 22 in the year 2009, then you are banned according to the Florida statute, as far as you are barred from going through the process of establishing or adjudicating paternity. They place some restrictions on how far back you can go. So it's a very complicated and involved process. So you need to talk to an attorney and give them your fact pattern, tell them your situation, and let them explain to you, based upon the Florida statute, whether you need to do something now, or whether you've lost the ability to establish paternity, whether there are places for you to look for documents that establish that you were acknowledged by your father. But make sure, if your dad's name is not on your birth certificate, that you take some steps now, so that 10 years from now, 20 years from now, you're not dealing with somebody who looked in your face every week, every month, every day, and now because of greed, they want to tell you, oh, I don't know whether that's your dad or not. Oh, let me see the DNA test. Let me see your birth certificate. Let me see this, let me see that. So, you might not care about that. You might think, well, it is what it is. I'm not trying to get anything if my father passed away. Or you might think differently. You might think, how dare they try to deny me? Everybody knows about me, but that won't be enough in a court of law. So if you are interested in finding out what you need to do about this, please sit with an attorney, tell them your fact pattern, listen to how the Florida law applies to your fact pattern, and do what you can do at this stage while you have this information, giving you some pointers about what you need to do. I'm attorney Bernita Williams, your heirs property attorney. If you would like to speak with me further about this, you can call me at 786-831-9483. That's 786-831-9483.